Let's face it. If you die today, and you do not leave behind a valid will, you are basically asking the government to determine who and how much your spouse, children, parents, or siblings inherit from your property. Welcome to my advocatus. In today's video, we are going to talk about what happens to your property or belongings after you die without leaving behind a valid will. Please remember to subscribe and share these videos. Your support means a lot. South African law acknowledges the principle known as freedom of testation. In terms of this principle, a person is allowed to write a will in which they identify the people who are entitled to inherit their property after they die. Therefore, in terms of South African law, if you are above the age of 16 years, the law generally regards you as having the capacity or freedom to write a will. Should you decide not to write a will, you are not forced to make a will. The law classifies you as a person who died intestate. The result of dying intestate is that the law uses a formula to determine who inherits your property. This formula is found in the Intestate Succession Act, 81 of 1987. Before applying the inheritance formula, please take note of the following points. Number 1. This formula applies to all types of marriages recognized under South African law. Number 2. The word spouse has a broader meaning in terms of this act. It includes all spouses in polygamous marriages. This position was confirmed in the 2009 Constitutional Court case of Hassam v. Jacobs and others. Number 3. This inheritance formula is hierarchical in structure. In other words, when you die intestate, your beneficiaries inherit according to the following ranking. The first beneficiary to be considered for inheritance in this ranking is the surviving spouse. This, however, only applies if the deceased was married at the time of their death. The second in the ranking are the descendants of the deceased. These include the children, that is, those who are born or were already conceived at the time of the deceased's death. Other descendants like grandchildren or great-grandchildren also inherit, but only as substitutes. Parents to the deceased are in terms of this formula only entitled to inherit if the deceased died without leaving behind a spouse or descendants. Lastly, the siblings of the deceased inherit from the deceased only if one or both parents are predeceased. The first rule of the inheritance formula provides that if you die without a valid will, and you are only survived by your spouse will inherit the entire intestate estate. Remember that in terms of the hierarchy for inheritance, we stated that your parents and siblings are only considered for inheritance in cases where you die without leaving behind a surviving spouse or descendants. Rule number 2. If at the time of your death, you are only survived by your descendants, then those descendants will inherit the estate jointly in specific shares. Rule number 3. If you are survived by a combination of your spouse plus descendants, the following rules apply. Number 1. If you and your spouse were married in community of property, your spouse will first receive half of the estate. This rule applies by virtue of your marriage being in community of property. In terms of such marriages, a spouse is entitled to half of the joint estate at the time of the dissolution of the marriage. From the remaining half, your spouse is entitled to what is called a child's share, or an amount of 250,000 rands, whichever amount is greater. The child's share is calculated as follows. Number 1. You start by dividing the monetary value of deceased estate by the number of your surviving children, plus 1. In a case where a child has not survived the deceased, or in other words, if the child died before you, but such a child had descendants before dying. Such a child will be added in our calculation, as if the child was alive at the time of your death. This rule applies, because the descendants of the deceased child will represent your predeceased child. After your spouse takes the child's share, or an amount of 250,000 rands, the remaining amount is then distributed amongst your surviving children, or their descendants by representation. In our next series on inheritance, we are going to look at a practical example of how to calculate a child's share in general, and also how it applies to polygamous marriages. We are also going to look at how, and when parents or siblings can inherit. If you enjoyed this video, please like and subscribe to our channel, as a way of showing your support. The growth of the channel helps us put out more content. Thank you for watching my advocates.